Well, hello and welcome to The Print Live today, where we discuss how the Supreme Court today has upheld the basic premise of freedom of speech and expression. The Supreme Court today ordered the immediate release of Prashant Kanojias, a vernacular journalist who was arrested by the Uttar Pradesh police for tweeting a video about Uttar Pradesh Chief Minister Yogi Adityanath. The charges leveled against him were of criminal defamation and that of corrupting a computer machine. However, the Supreme Court bench of two judges pulled up the UP government, saying that their reasons for arresting the journalist was not proper. They also said that this crime was not murder, that they had to arrest the journalist immediately, and also criticized the magistrate's order of remanding him to a 14-day judicial custody. We are at The Print going to dissect this particular order of the Supreme Court and also see whether this particular order from the Supreme Court upholding the right to liberty of an individual will send a clear and loud signal to all the leaders who are in a habit of slapping random cases on journalists after they come out with stories which perhaps are not in their direct favor. So just to elaborate on the provisions that under which Prashant was arrested, it was section 500 of the Indian Penal Code, which is criminal defamation, and the next section was section 66 of the Information Technology Act. Particularly, criminal defamation is something which a person it's a non-cognizable offense. That means that the police cannot take cognizance of the offense on his own or on her own. There needs to be a case at a local police station against the person, to which the magistrate or the police take cognizance, and thereby the arrest is made. This particular section was blatantly flouted in Prashant Kanojias' case, whereas the UP police in Hazratganj police station in Lucknow filed an FIR on their own suo motu action against the journalist Prashant Kanojias. Again, if we talk about section 66 of the Information Technology Act, that is particularly to do with about corrupting computer machines, and this case, you all would agree with us, that had nothing to do with corrupting a computer machine. So the Supreme Court actually pulled up the UP government, saying that the two charges leveled against the journalist does not substantiate in a proper way. Thereby, they again got out a press note in the evening of the arrest and added two more sections to it, which were again cognizable in nature. The sections were of section 505 of the Indian Penal Code and 67 of the Information Technology Act. Now, section 67 of the Information Technology Act usually talks about anything that creates a law and order situation, along with section 505 IPC, which also generates communal hatred in the society. The Supreme Court was of the opinion that all these sections do not substantiate the charges against Kanojia in the present case. So we wait for your questions here. If you have any questions, let us just check. Yeah, there is a question from Neha. What about Rahul Gandhi saying it is foolish? This happened during UPA era also. Any examples? Well, Rahul Gandhi saying that it's foolish does not really bode well, because recently there have been arrests, or journalists have been arrested in Karnataka as well, where the Congress party is in power. It's very pertinent to mention that the clause of criminal defamation has been continuously used against journalists or whistleblowers to silence them, because this clause has been used or broken down in the court to prove that a goodwill of a person has been compromised. So this particular section has also been debated in research circles in the academia, that should be done away with. Why criminal defamation is not needed in India was a much heated topic last year when Mamata Banerjee ordered arrests of a few scribes, that only civil defamation should be a part of the statute or the law book. So I guess Rahul Gandhi saying that it is foolish, it's a little confusing here, since the Karnataka government itself ordered such arrests in the near past. Tarun has put a question. UP police alleged that the accused made objectionable comments against the CM and tried to malign his image. How has the SC responded? Well, Tarun, the SC has responded saying that why was the urgency to arrest Prashant Kanojias? This particular thing comes to light because the court has said that he did not commit a crime under section 302 of the Indian Penal Code, that is murder, right? There is also an additional provision in law that section 41 of the CRPC mandates that the magistrate magistrate, this case must go to a magistrate, and the magistrate must send a notice to the accused saying that, if you don't furnish a reply, then we have to arrest you. This particular provision was completely done away with in Prashant Kanojia's case. So these particular legal loopholes and legal lapses forced the Supreme Court to give a very strong verdict today and release Prashant Kanojia immediately on bail. However, just to be clear, the court has also said that the UP police can proceed in accordance with law, and it has also said that this order should not be seen as an endorsement of Prashant Kanojia's tweets. But then again, they have said that the freedom of liberty, or right to liberty of a person, indeed triumphs there to be under the confines of the judicial custody. Okay, we have another question from Yaman, that is, was this illegal and unconstitutional? Well, Yaman, we have to note that Nitya Ramakrishnan, who was arguing for Prashant Kanojia on behalf of his wife, Jigisha, clearly said that this entire arrest was arbitrary, illegal and unconstitutional. The primary fact that they highlighted was a DK Basu versus State of West Bengal case. Now, this case was of illegal confinement, and this petition which was filed by Jigisha today was a habeas corpus petition. So we have to understand the legal dynamics involved in this case. They said that the immediate arrest of the journalist was a violation of Article 14, that's their right to equality, Article 21, that is right to life, and Article 19(1)(a), that's right to freedom of speech and expression. Now, these three rights are essential fundamental rights of an individual enshrined under the Part 3 of the Constitution, which cannot be breached unless and until there is huge exigency, or there are certain exemptions given under section Article 19 which have to be fulfilled. So I think the court justified its order on these particular grounds today. We have more questions here from Wasim. He says that, what about politicians saying everything to each other during elections? Why aren't they being arrested? Well, a very good point. This is also defamation. Objectionable comments against the CM and trying to malign his image. Politicians' image also gets maligned in this way. Wasim, I think your point is well taken, but we have to also understand that the Prashant Kanojia, the individual here, the court has not endorsed his tweet. Let's get the fact very clear. The court has not said that what he has tweeted is harmless. What he has tweeted, it does not malign the reputation of the UP Chief Minister. What they have harped on is the legal way in which the arrest was made. The entire premise of the case was the arrest was arbitrary, illegal and unconstitutional. They did not say the act of Prashant Kanojia was not, was not illegal or unconstitutional. That is why he has been given a bail. Now, bail is a temporary release from a jail. The charges have not been quashed. If the court would have quashed the charges, then your question would have been true, that why is the politician's image not taken seriously in this case? So I feel this answers your question. Then we come to Shubham. You say that, have you ever come across remand for 11 days in such a case? Sit behind the bars day after day and challenge the order. This is not very fair, Strand. Why was this context used? Well, my dear Shubham, I don't think I'm getting the gist of your question much, but what I believe is that you are saying that, what about a person who is being remanded to custody for 11 days and what remedy do they have? Well, the remedy today exercised by Prashant Kanojias, his wife and his lawyers, was filing the habeas corpus petition, and this petition stated that his fundamental rights were being infringed. Let us also go back to some previous cases, because journalists, this is not the first attack on the journalist. If we just have a quick recap, I think about 4 to 5 journalists were arrested in the last 1 or 2 weeks. Also, I think there's a case by the UP CM again arresting another journalist a day ago. So I don't think this is a targeted attack on Prashant Kanojia only. It's on the journalist community also, who are going to report facts which might not be very comfortable for the ruling dispensation. And the court says that the individual liberty of a person has to be respected. However, if the person has tweeted out a video, and in this case the video was of a woman proposing to the chief minister, and then he has added a very quirky line to it and has tweeted it out, the court has said that even they bear the brunt of the social media. We have to understand the judiciary in this case has actually gone out to say that, and has admitted the social media is not always in their favor. There are so many verdicts, whether it be right to privacy, Article 377, whether it's about right to life, hundreds of judgments. Deepak Mishra, Justice Indira Banerjee, we have always criticized their verdicts. So on the social media also, and we have always not been very nice. At some times we have been nasty as well. So the court has actually said that, we bear the brunt of social media, but that does not mean that we arrest an individual. Arresting is a very grave step. Before that, you have to serve a notice. If the notice is not being replied to, the magistrate has to take a conscience call on whether there is a remand needed or not. Remand is usually in cases of terror, in cases of murder, in cases of mutilating someone, or harming someone grievously, or causing communal tension in an area with an intention to create riots, etc. These are the cases where remands are usually given. So in this case, I will not get into the context of whether the tweet was harmless or harmful, but we'll also get into the context that it was just a tweet of someone expressing what they believe in, and that necessarily does not mean that a person has to land behind the bars. We have a question from Abhinav Pandey, who says that why no action is being taken by the police when a similar tweet are done against the Congress. Well, when such tweets were done against the Congress, I just was responding to Neha, I think, and I said that Karnataka also ordered such arrests recently of journalists under section 500 of the Indian Penal Code of criminal defamation. So I think this is not about BJP or Congress. This is about invoking a section invariably to target a community, to target journalists or whistleblowers from telling the truth to the world. But here he was not even trying to tell a news. He was just putting his opinion across about the CM. So this particular thing which you're saying that the Congress has not taken a legal remedy is in fact not correct, because Congress has also resorted to this section which the UP police has charged Prashant Kanojias with. And now we come to what about Abhijit Mishra's case? How is this different? Well, Abhijit Mishra's case was slightly different because of the sections involved and the sections invoked in this case. We also have to look at this case in the light of the fact that the press release was issued within like 3 to 4 hours, and additional sections of section 67 and 505 were invoked, which had more to do about transmitting obscene materials. So Justice Banerjee and the Supreme Court bench actually went on to say to the UP Council, to the UP Uttar Pradesh State Council, that how do you justify section 505 of the IPC, which talks about communal tensions being created in the state because of the tweet, and how do you justify section 67, which talks about obscene materials, because this a press conference which was being held by the girl who was expressing her love for the chief minister. So how was this obscene? So these all facts will now again come to play, because this case is not closed. He has only got bail. I'm sure this case will now be argued on merits, and when this case reaches the argument on merit stage, thereby we'll all come to know whether the court actually quashes the charges or upholds it against Prashant Kanojias, and thereby I think your court will be your question will be answered. Okay, there's a very interesting question. Why not the local court or the high court? So Nikhil asked this question. It's a very important question. See, under law, you approach the Supreme Court if there is a very urgent exigency, especially a violation of the fundamental right. Article 32 of the Indian Constitution gives us the right to approach the top court of the country to seek legal remedy if there is an immediate infringement of right. If we adhere to Article 226 of the Constitution and go to the High Court, then there is another chance of this court being taken up to the Supreme Court, and the time lapse which happens affects a person. We have to also know that Prashant Kanojias is an independent journalist. He works as a vernacular medium journalist, and the period which he will spend in the jail, which also mean impact on his monetary life cycle, or the monetary aspect of his household. So that this is also a reason why his wife approached the top court, because a time lapse in this case would have costed the family. And the Indian law gives us the right to approach the top court in case there is an emergency. Talk about abortions, right? When you are 22nd week pregnant and you need to have a medical termination of the pregnancy, you don't go to the High Court, you don't go to the trial court, you go to the Supreme Court, because you need to get the abortion done in the next few weeks. So that is why this thing happened. So I think we have delved into a lot of questions encompassing this case, and this case will now again take place in the court. Perhaps this case will be transferred to the High Court now, since the immediate issue has been addressed by the Supreme Court. We'll look into the case more deeply to see whether at all, the charges against Kanojia stands established or he is quashed. But indeed, today's Supreme Court verdict saying that the right to liberty and the freedom of speech and expression is paramount and important gains a lot of significance here, because such cases which are being slapped against journalists right, left and center would at least stop for a while. This is Debayan Roy for The Print.